I screwed up. I should have been more careful. I made a mistake and now I'm hurt. I can't sue my employer. This was my fault. If you work offshore and you've been injured, you might be thinking exactly this, and it might be costing you millions of dollars. Because under the Jones Act, the fact that you made a mistake, it doesn't prevent you from recovering compensation if your employer was also negligent. I'm maritime injury attorney Matt Schaefer, and in this video, I'm going to explain why it was my fault doesn't matter under the Jones Act, and why you might still have a valuable case even if you think you caused your own injury. Let me start with the legal principle that changes everything: comparative negligence. Under the Jones Act, you can still recover money even if you were partially responsible for your injury. As long as your employer was also negligent, even slightly negligent, you can win your case. This is how it works. If a jury finds that your employer was 60% at fault and you were 40% at fault, you recover 60% of your total damages. If your total damages are $2 million, you get $1.2 million. Even if you were mostly at fault, say 70%, where your employee was 30% negligent, you could still recover $600,000 from that $2 million case. This is completely different from what most offshore workers think. They assume that any fault on their part destroys their case, and that's not true under the maritime law. Let me give you a real example. I represented an oil rig worker named Carlos who was injured in an explosion. Carlos had been smoking in an area where he wasn't supposed to smoke. When investigators found his cigarette butt, everybody assumed Carlos was 100% at fault. But we investigated further. We discovered that the explosion was caused by a gas leak that had been reported 3 times over the previous month. The company knew about the dangerous condition and failed to fix it. Yes, Carlos shouldn't have been smoking in that area, but the company should have known the gas leak was going to be dangerous if it continued for a month. The jury found Carlos 25% at fault and the company 75% at fault. Carlos recovered $3.6 million from a case that everyone initially thought was hopeless because it was his fault. Here's another key difference. Under the Jones Act, your employer only needs to be slightly negligent. They don't have to be grossly negligent or reckless. Slight negligence is enough. What counts as slight negligence? Failing to maintain equipment properly, not providing adequate safety training, using worn or defective gear, creating unsafe work conditions, poor supervision, inadequate safety procedures, rushing jobs to meet deadlines. I've won cases where the only employer negligence was failing to inspect equipment on the required schedule, or not providing proper safety equipment, or inadequate training on new procedures. Even if you made a serious mistake, even if your employer was slightly negligent, you still have a valuable case. Let me walk through some common scenarios where workers think they have no case because it was their fault. Scenario 1, you're supposed to wear a safety harness, but you didn't. You fall and get hurt. Your thought, well, I wasn't wearing my harness. It's my fault. The reality is, was the harness available? Did you receive proper training on when and how to use it? Was there adequate supervision? Were safety rules consistently enforced? If your employer failed in any of those areas, they're partly at fault, even though you weren't wearing the harness. You operated a crane or winch incorrectly and caused an accident. Your thought is, I didn't follow procedure. It's my fault. The reality, were you properly trained on that equipment? Was the procedure clearly written and posted? Were you under pressure to work faster than safely allowed? Was the equipment properly maintained? Employer negligence in training, supervision, or equipment maintenance can make them liable even if you used the equipment wrong. Working in a restricted area and got hurt. Your thought, I wasn't supposed to be there. It's my fault. Why were you in that area? Were you told to go there by your supervisor? Were proper barriers in place? Was the danger clearly marked? Was there adequate supervision to prevent unauthorized access? If the company failed to properly secure dangerous areas or gave you conflicting instructions, they share liability. If you're under the influence, this is the most difficult scenario, but even here, you might still have a case. If you were drunk or high and got hurt, your recovery will be significantly reduced. But if your employer was also negligent, if equipment malfunctioned, if safety procedures weren't followed, if dangerous conditions existed, you might still recover something. Employers love it when injured workers blame themselves. It makes their jobs so much easier. If you think it's your fault, you're less likely to investigate what the company did wrong. You're more likely to accept a small workers' comp settlement. You're less likely to hire a lawyer. That's why the company's safety officer shows up at the hospital with an incident report that focuses on what you did wrong. They want to establish a record of your fault before you have time to think about what they did wrong. But here's what they don't want you to think about. Why was that dangerous condition allowed to exist? Was there proper training and supervision? Was equipment properly maintained? Were safety procedures adequate and enforced? Did company pressure contribute to unsafe shortcuts? When you hire an experienced maritime lawyer, we investigate all aspects of your accident. Equipment maintenance records. Did they inspect and maintain equipment properly? Were there previous problems with the equipment that injured you? Were you properly trained for the work you were doing? Were safety procedures clearly communicated? Did the company have adequate safety rules? Were they consistently enforced? Were you under pressure to work under unsafe practices? Was there adequate supervision? Had similar accidents happened before? Did the company learn from those previous incidents? Was the company following Coast Guard, OSHA, and other safety regulations? Often, this investigation reveals employer negligence that wasn't obvious immediately after the accident. I represented a deckhand who was injured when he slipped on a wet deck. Everyone initially assumed it was his fault. He should have been more careful, should have worn non-slip shoes, should have paid attention to where he was walking. But our investigation revealed the deck drainage system hadn't been properly maintained for months. Water was accumulating in areas where it shouldn't have been. The company knew about the drainage problem, but decided to defer repairs to save money. Proper non-slip decking material had been removed during maintenance and never replaced. There was inadequate lighting in the area where he fell. The jury found the deckhand 30% at fault for not paying attention, and the company 70% at fault for creating unsafe conditions. He recovered $1.4 million when everyone initially thought was a simple slip and fall with no company liability. Look, I get it. If you made a mistake that contributed to your injury, you feel guilty. You feel like you shouldn't profit from your own mistake. But that's not what this is about. This is about holding employers accountable when their negligence contributes to accidents. This is about making sure you can pay your medical bills and support your family after serious injury. The Jones Act recognizes that maritime work is dangerous and that accidents usually result from multiple factors. Pure employee fault is actually pretty rare. There's usually some employer negligence mixed in. Don't let guilt prevent you from exploring your legal options. Even if you think the accident was your fault, you might be wrong about the company's role. And even if you were partly at fault, you might still be entitled to significant compensation. If you've been injured working offshore and you think it might have been your fault, watch my video on what the Jones Act is and how it works. Understanding your rights is the first step to getting fair compensation. And if you want professional evaluation of your case, including an honest assessment of how any fault on your part might affect your recovery, there's a link in the description for a free consultation. We handle these cases nationwide. We only get paid if you win, and we'll tell you the truth about your case, even if that truth is uncomfortable. Don't let "it was my fault" cost you the compensation you deserve under maritime law.